Next, members, Representative Frazier, House File 1374, and I believe you have a motion for us.
Yes, Mr. Chair, I have a motion to. Are we laying this over for? Are we laying this over?
On judiciary.
Right. This motion, I would like to refer this bill to judiciary.
Very well. Representative Frazier moves to refer House File 1374 to the Judiciary Committee. Representative Frazier, your bill is before us.
Thank you, Mr. Chair. As many of you are aware, during the July 2020 special session, the legislature passed the Minnesota Police Accountability Act. This act included the creation of a centralized database of officer misconduct data. The data included in the database is currently all public data, meaning you could go down to your local law enforcement agency and make a data request for the data, and the agency would have to give you, or should be able to give you, that data. The purpose for collecting this data is to require the post board to evaluate the effectiveness of officer training, to assist the Citizens Council in accomplishing its duties, to allow for the council and the complaint investigation committee to identify patterns of behavior that may suggest an officer is likely to violate a model policy. And lastly, the post board is required to submit an annual report to the legislator that includes summary data related to officer misconduct. A copy of this report must be available for the public on the post board's website. House File 1374 expands the current database to include certain private police officer data. As with the public data currently being reported, the chief law enforcement officer will also be required to submit real-time private data. The data classification will not change. The classification will remain private as defined in Chapter 13. The intent in making this change is to capture data that would assist the post board in developing an effective early warning system to identify problem officers. Currently, the public data shared to the post board does not encompass complaints that did not result in formal discipline, because that data is not considered public. Passing House File 1374 into law will provide the post board with the data it needs to effectively develop and ultimately implement the early warning system as was intended when the Police Accountability Act was voted into law in the summer of 2020. Mr. Chair, that concludes my remarks, but I do have two testifiers that I would like to have them provide more insight into why this language is necessary.
Very well. I see that you have Dr. Gina Erickson from Hamline University, and then Director Eric Missel from the Post Board. So let's begin with Dr. Erickson, if you can come forward and state your name for the record and provide us with your testimony.
Yes, hi, thank you for having me here today, Mr. Chair and members of the committee. My name is Dr. Gina Erickson. I hold a PhD in sociology and I'm an associate professor in the Department of Criminal Justice and Forensic Science at Hamline University. I'm here today to speak about the primary need for data on officers in Minnesota. Last summer, my colleagues at Hamline and I made several recommendations, both formally to the Post Board and publicly in the news media, about exactly this kind of data collection. Minnesota was once a pioneer in thinking about law enforcement oversight. However, the last 5 years in Minnesota have brought several unfortunate and high-profile civilian deaths at the hands of police officers. Collecting data earlier and more often is the way we can work toward proactively preventing these kinds of tragedies in the future. Current Post Board data shows only a fraction of complaints against officers, based only on reports that are made public. Following the death of Mr. George Floyd, the investigation of his accused killer, former officer Derek Chauvin, brought to light many complaints against him. These complaints live solely within MPD and would not have been brought to light without the investigation following Mr. Floyd's death. And the complaints of use of force by Julian Hernandez, Zoya Cody, Jimmy Bostic, and Sir Riley Pete, among others, would not have been recorded in any coordinated way. And former officer Chauvin would likely have continued to climb the ranks in MPD. This bill expands the current database to include certain kinds of private officer data. This data will remain private and will be reported by the police chiefs to the Post Board. So far, 31 states have introduced 124 bills to promote this kind of transparency and legislation. As this shows, Minnesota, once a leader in police oversight and regulation in the nation, is now falling significantly behind other states. The current statute does not allow the Post Board to capture the data necessary to prevent critical incidents of use of force. This bill would be a major step forward in moving this goal. We need data collection of this nature to ensure evidence-based criminal justice practice and policies at all levels and for all persons, and to centrally capture the kind of data necessary for early intervention to prevent civilian lives. Thank you.
Thank you, Dr. Erickson. I hope you can stick around for a bit in case there are questions.
Yes, Mr. Chairman, I will.
Very well, thank you. So next we have Director Misselt from the Post Board. Director Misselt, welcome to the committee.
Thank you, Mr. Chair, members. My name is Eric Misselt. I'm the Executive Director of the Minnesota Post Board. I have a couple of additional comments I would add to the testimony that was already given regarding this legislation primarily from the practical standpoint of what it means, the way it's currently written versus what is proposed. As was pointed out, the way it is currently written, we would not be able to collect the data that we would need to carry out our charge under the statute that was passed, the reform bill essentially that was passed in 2020. I want to emphasize a couple of things. One, that as was mentioned, the collection of this data does not change its classification. It would remain private, even though it would come into the Post Board. And as a result, any requests for information would be handled as private and or licensing data. One of the other issues is that as we are developing the database that is being worked on to capture this information that CLEOs, chiefs and sheriffs will be required to report as of July 1st, we have to have the knowledge of what we can actually configure the software to collect. And as of right now, the way the statute exists, we would only be able to collect that that public data. And that would basically be the fact that there was a complaint and the officer's name. And that would be the end of it. We would not be able to collect other data. And while I am sure an agency could potentially provide that data, we know based on experience, our agencies that will not share that data, whether it's because of being advised by their legal representation or otherwise, or just choosing not to. And this is an important step in order for us to get this data and use it as it was intended.
Thank you, Director Misselt. Representative Frazier, before we go to questions, I note that there are several amendments. Is it your counsel we take the amendments up first and then open up for a broader conversation? Is that a
That's fine, Chair.
Yeah, all right. Very well. Then there is an A1 amendment. And I believe is that your amendment, Representative Frazier?
No, I haven't offered any amendments.
Oh, okay.
That's my amendment, Chair.
Oh, very well. Representative Hollins. And you're wishing to move the A1 amendment?
Yes, Mr. Chair. That is my motion.
Representative Hollins moves to amend House File 1374 with the A1 amendment. Representative Hollins, to your amendment.
Thank you so much, Mr. Chair, and thank you, Representative Frazier, for bringing this important legislation. My amendment is fairly simple. What I would like to do is include probation in the Information Center and Clearinghouse subsection, so subdivision 6. What it does is just include probation and probation terms, condition of probation, just trying to get that probation data included in the data that's collected, as well as there's one note of recidivism, because I think that's a really important aspect of data that we need to collect and understand. Oh, I apologize, my phone is ringing. Of data that we need to collect and understand when making decisions going forward. And so I hope this is viewed as a friendly amendment. I don't think that it is terribly controversial, but that is my motion and my amendment.
Representative Frazier.
I do not see it as controversial, and I do see it as friendly, and I would be willing to accept that
Very
friendly amendment.
Very well.
Chair Mariani.
Representative Otney.
Thank you, Chair Mariani. Representative Johnson.
I'm hearing another voice.
This is Representative Johnson
Representative
dealing with the amendment. With this amendment, I understand why this amendment's being offered, but that really has nothing to do with this bill. This is sentencing guidelines, and the bill is talking about post board. With sentencing, probation is part of the sentence, and unfortunately, if we do add this, this is going to have to go to Ways and Means because this is going to add a whole bunch of fiscal costs to sentencing guidelines, which is not in this current bill. I believe we have another bill coming up that sentencing guidelines will be involved with. That this amendment could be looked at that point, because adding this information for sentencing guidelines to do, they're going to have to build programs and all sorts of stuff in order to obtain this information. Unfortunately, they should be doing this already because probation is part of their sentence, but they are not. So I'm going to politely ask that the amendment be withdrawn at this time and be brought up in the proper bill, because I would like to actually get this bill to the floor because I think it's a good bill, some aspects of it, but we were sure to add it on if we want to delay it getting there.
Representative Johnson, I do think your observation about assuming this amendment moves on, going to Ways and Means it makes sense to me. I don't see a conflict in adding this language to the bill. We heard as much from the chief author. It's certainly up to the author to reject the amendment, but I think the motion to amend is appropriate. I think it would probably, to your point, require adjustment of the final motion on the bill. Representative Novotny.
Thank you, Chair Mariani. My question is for the author, Representative Frazier. I don't see a breakdown in what data would be transferred to the post board from your bill. So any complaint, any discipline from the way I read it would be related to the post board. And maybe you can clarify, because my concern would be, say, for example, a licensed peace officer in the outstate drives off from the gas pump with the hose in his squad. Therefore, ripping the hose out, or say, for example, he or she left their PBT on the hood of their car at a juvenile party and drove off losing a PBT. And in 33 years, maybe that was the only 3 complaints he ever gets in his personnel file. Would that be something that would be reviewed and analyzed by the post board? I'm in Sabika, Minnesota. Is that something that, the post board, the post advisory board, that this would be referred to? Is that something they're going to be reviewing? Could you clarify that?
Representative Frazier.
Thank you, Mr. Chair. Thank you, Representative Novotny. I've got family in Sabika. So I have to look you up when I'm in town. Those would be some unfortunate situations. I will probably ask for some feedback from Executive Director Missou on this, but the post board would be deciding what information and how they would analyze that information and which information would be pertinent for the system. As ED Missou stated, they're developing this system. So I'm pretty sure they're going to get information from the experts on which data would actually need to go into the system to help with the early warning system. But I will defer to Mr. Missou if he has anything to add to that.
Director Missou, do you have anything to add to this point?
Yes, thank you, Mr. Chair and Representative Frazier. To your question, Representative Novotny, that is in fact what we are in the process of figuring out right now, actually, is what, as the legislation says, that the post board determines is necessary to do those different things. I did a presentation for the Chiefs Association just the other day, and that is a very good question that came up during that time. And what we'll have to do as we develop this software is define very clearly to the agencies, what constitutes a complaint, what level of complaint should come to the post board. And that's not clear in the legislation, but we have a pretty good idea of where that stands. An example of the where the confusion is that agencies all across the state and really across the nation have different definitions of what constitutes a complaint. There are folks who, agencies that will consider, say, a verbal discussion or correction on, let's use your example, the PBT on the front of the squad, that somebody finds and tells the agency about it, and they call the officer in and they counsel them. That would not be considered discipline in some agencies. Others might consider that discipline. So we would have to define that, and I grant that that's not entirely clear here. But I think the intent, certainly from my discussions with members of the board, and the intent of the legislation, as I understand it, is that we would want to filter out those. I'll call them minor. I mean, honestly, minor and probably not complaint level kind of stuff that we don't really want to gather. So, but in truthfulness, it is to be determined at this point.
Members, we are on the A1 amendment. Representative Novotny.
Well, just to clarify, I was asking for a friend. None of those examples may or may not have been mine. Representative Frazier, I think those are all things that we should clarify. That I think this should be part of the bill going forward before we just ask the post advisory board to do this for the. So I think I'm going to vote no on this until we get some clarification. I would like to offer to work with you on language on things to get those in, but until we get clarification, I think that I'll be a no, and I would recommend that.
Thank you, Representative Novotny. To the A1 amendment, Representative Raleigh.
Thank you, Chair. No, I'm to the bill once it's into the shape that the author wishes.
Very well. Anyone else on the A1 amendment?
Yes.
Pinto?
Thank you, Mr. Chair. I just wanted to verify, just kind of process-wise, as I understood, the concern is that potentially the amendment might add a cost to a bill if the bill is policy only. It seems like it could still go to judiciary. I just want to make sure I'm just kind of clear on, and I'm supportive of the amendment, I should note, and supportive of whatever the author wants to do with the bill. I just kind of want to make sure I understood what the situation is.
Yeah, no, good point. It certainly can still go to judiciary, but I do think Representative Johnson made an important point about it at some point, wandering over to Ways and Means, but it could certainly continue on the current track. That will be an appropriate thing to do, to have judiciary look at the policy implications. Obviously, data privacy issue is their jurisdiction.
And just a quick follow-up, Mr. Chair.
Yes, Representative Pinto.
Thank you. So it seems like, I guess I'm understanding correctly, then I guess the question, just to confirm with the bill's author, Representative Frazier, then, is that if the underlying bill does not have a cost currently, potentially this, in my view, really good amendment potentially adds a cost. I suspect it'd be a pretty small cost, if there even is one, which I guess we need to find out. Just want to confirm that he's supportive of doing this in that way. And again, if he is, I'm certainly supportive of it as well. I just want to make sure I'm clear about what's going on.
Yeah, I do believe Representative Frazier was amenable to accepting the amendment, but Representative Frazier.
Thank you, Mr. Chair. Representative Pinto, I am amenable to the amendment.
Very well. Any further discussion on the A1 amendment? If not, then Representative Hollins renews her motion to adopt the A1 amendment. The clerk will take the roll.
Mariani.
Aye.
Chair Mariani, aye. Vice Chair Frazier.
Aye.
Vice Chair Frazier, aye. Representative Johnson.
Aye. This information should be collected now.
Representative Johnson, aye. Representative Edelson.
Aye.
Representative Edelson, aye. Representative Feist.
Aye.
Representative Feist, aye. Representative Grossell, excused. Representative Hollins.
Aye.
Representative Hollins, aye. Representative Hewitt.
Aye.
Representative Hewitt, aye. Representative Cleaborn.
Aye.
Representative Cleaborn, aye. Representative Long.
Aye.
Representative Long, aye. Representative Lucero.
Yes.
Representative Lucero, aye. Representative Mueller.
Mueller votes yes.
Representative Mueller, aye. Representative Novotny.
Novotny, no.
Representative Novotny, nay. Representative O'Neill.
O'Neill votes no.
Representative O'Neill, nay. Representative Pinto.
Aye.
Representative Pinto, aye. Representative Poston. Representative Poston excused. Representative Raleigh.
Raleigh, aye.
Representative Raleigh, aye. Representative Vang.
Aye.
Representative Vang, aye. Representative Zhang.
Aye.
Representative Zhang, aye.
Lucero, yes to no.
That concludes roll call with 14 ayes and 3 nays.
Very well, with 14 ayes and 3 nays, the motion prevails, and House File 1374 is amended with the A1 amendment. There is an A2 amendment. Is someone moving the A2 amendment?
Chair Mariani, that is my amendment.
Representative Johnson moves adoption of the A2 amendment. Representative Johnson, to your motion.
First of all, I misspoke on the last amendment. I have a problem with the bill itself. This is try to fix some of the issues, but the amendment, the A1, I was in favor of, as that information should be collected now so we can get proper information that we need. But I have an issue with the data privacy issue. So this is an amendment to try to clear some of it up. With unauthorized release by a member of the board of or the Ensuring Police Excellence and Improving Community Relation Advisory Council, it releases this private data, it would be a gross misdemeanor. This is very sensitive data that they're collecting, and it needs to be protected. Make sure it's protected extremely well, especially with the some of the citizens on the board might not understand how critical it is and how important Chapter 13 is.
Very well, Representative Johnson, there is an amendment to the amendment. Is that yours as well, or is it someone else?
That is mine as well. And the amendment is in the information being collected. Something that's also very important to understand is who the complainant is on these complaints against officers. I can take an example of a gentleman, a person in my community by the name of Jim. In 1 year alone, he had over 25 complaints against officers. And it was the standing orders that all 4 departments, the State Patrol and the conservation officer in our area would not talk to this gentleman unless we had a tape recorder going, because every time he talked to an officer, he'd file a complaint. And so we never knew what was going on, what he was going to do. I've talked to others officers across the state, and they have individuals in all these areas. Every time they have contact with law enforcement, they always file a complaint. So I think it's important that not only we look at the complaint, the board look at the complaint itself, because all these complaints are going to have to be forwarded to the board and the secondary board. But it's also, I think it's important to understand who's filing the complaints. What's the issue is, if there's a pattern of a person continuously filing the complaints because they have an vendetta against an officer, I think that is also important information. So I'd like this amendment to be added on to the amendment.
Very well. So Representative Johnson moves to amend the A2 amendment with the A3 amendment. So that's the motion before us, members. Representative Frazier.
So are we, Mr. Chair, thank you. Representative Johnson, thank you. Are we taking an action on the amendment to the amendment, and then we're going to decide if we're going to move forward after that?
Yeah,
with that amendment.
Yes, Representative Frazier, we will take action on the A3 amendment to the amendment, which is an amendment to the amendment. And then we still will need to take action on the underlying amendment.
Okay. I am fine with moving forward to allow Representative Johnson to amend his amendment.
All right, very well. Representative Johnson, voice vote okay?
That would be fine.
Very well. All in favor of the A3 amendment to the A2 amendment, please say aye.
Aye. Aye.
Aye.
Opposed, same sign. Motion prevails, and the A2 amendment A2 amendment is amended with the A3 amendment. I thought I heard something. Okay, perhaps not. All right, so now we have the A2 amendment as amended before us. Representative Frazier.
Yeah, so Representative Johnson, I appreciate you putting this amendment forward. There are parts of it I do agree with, the complaint process with collecting all of that data, but I absolutely think that the post board will be collecting that data. In fact, this gives them the ability, the new language that I hope will go into law will give them the ability to collect that data. If they're collecting complaints, they will get everything that comes along with that complaint. So it would include the individual that filed the complaint, if that exists. I mean, I think that's one of the things we have to think about too. I do believe as we stand today, local law enforcement agencies have the ability to set up their complaint processes, and there may be some that allow it to be done anonymously. So in those cases, it will be pretty difficult for the post board to collect that information if it's an anonymous complaint. But I do think it doesn't prevent the post board from having conversations to identify the particular situation that you just added. I believe the local law enforcement agency will have insight into that, could provide that insight to the post board if it's an individual that is just constantly submitting frivolous complaints, especially if they can do it anonymously and not have any potential accountability or consequences for that. In regards to increasing I am troubled by increasing from a misdemeanor to a gross misdemeanor, because currently now it is a misdemeanor for an individual to violate data privacy under Chapter 13. And most agencies require to do trainings on that. So I am not aware of a rash or a trend where you're having citizens that sit on these advisory boards that are violating the Data Privacy Act, whether there's lawsuits coming or there's been charges of misdemeanors and convictions that are happening. So I don't think that's necessary at this time, because I think there are provisions in place already to address and hold folks accountable. And I think there's tons of training that agencies are required to do to ensure that that type of data privacy violation, that those type of data privacy violations actually do not occur.
Well, and Representative Frazier, just to be clear on the record, so the A2 lifts us to a gross misdemeanor. However, currently a violation of 13.08 is also actionable, is it not? Isn't that a misdemeanor?
It's currently a misdemeanor.
Yeah, okay, very well. Director Missel.
Thank you, Mr. Chair. One thing, and I don't know, I get the sense from the conversation, and maybe this has not been discussed, but I know it's something that we looked at when we were considering the legislation and particularly this change. I'm not an attorney, but I would suggest that maybe we should have, or it would be prudent to have an attorney weigh in. It's my belief, again, based on my very layman-like position on this, I am not certain that there's anything in either the original reform legislation or in the current legislation that actually would allow the advisory council to have access to that private data. We would certainly share that, obviously, in meeting the need of the statute in terms of providing information for them to do their job. But that would be, I don't see any basis for us to be able to share actually private data with the advisory council. That is only a function of the board, if I'm not mistaken.
Perhaps our council might have some thoughts on this.
Chair Mariani.
I'm sorry, whose voice is that?
Representative Johnson.
Representative Johnson.
The reason I brought this forward is because right in the current statute, it's in the bill as well on 2.12, where it talks about the data. Assist in ensuring police excellent and improving council advisory council in accomplishing their council's duty, which says they can't have access to the data. That's why it's important to follow up on this. And also, the law enforcement world, there's state statutes that make it a higher offense if the officer that was involved is an undercover officer, because the jurisdiction is forbidden by law to release that data. They can't even admit they're an employee with their department.
Very well. I'm wondering if council may have some thoughts to share.
Mr. Chair?
Yes, Mr. Devo, I think you heard perhaps Director Missel's inquiry.
I did, Mr. Chair, and I don't have a direct answer. I think this is certainly something that would be appropriate for the Judiciary Committee, where our data practices expert. This statute was drafted with the idea that it would be public data, so this wasn't a concern when the language was drafted. And as Representative Johnson has noted, the intention was that the data would be shared with the council to help them make their recommendations to the board. So I think this is a technical issue that would need to be sorted out if this language is adopted or considered in a subsequent hearing as to whether there would need to be exceptions to current law with these citizens having access to the data.
Okay, very well, thank you. Representative Novotny, I see your hand up. Is it to this amendment or just to the other?
Sir, left over.
Okay, very well. I don't see any further discussion.
Mr. Chair.
Yes, Representative.
If I just could add just a couple of comments to that. I do think currently, and I think Mr. Missel covered some of this, so he alluded to it. Currently, the Post Board handles private data, and it does not share it with some of the most sensitive data it handles on our peace officers that are submitted to the Post Board, and it does not share that data with anyone outside the purview that does not that the Chapter 13 would not allow that data to be shared with. I would see this information and to be handled the same way. It still retains the classification as private data, which means the Post Board will still have to maintain that privacy with that data. And there are ways to share the information that's collected in the database in a summary way where it doesn't de-identify or it doesn't identify the particular peace officer that it relates to. But I agree with what council said is we can touch on these technical pieces and figure that part out. But I don't think that there would be an issue with having that data maintain its privacy within the database.
Okay, very well. Thank you, Representative Frazier. Representative Johnson renews his motion that the A2 amendment as amended be adopted. The clerk will take the roll on the motion.
Chair Mariani?
No.
Chair Mariani, nay. Vice Chair Frazier?
Nay.
Vice Chair Frazier, nay. Representative Johnson?
Aye.
Representative Johnson, aye. Representative Edelson?
No.
Representative Edelson, nay. Representative Feist?
Nay.
Representative Feist, nay. Representative Grossell, excused. Representative Hollins?
Nay.
Representative Hollins, nay. Representative Hewitt?
Nay.
Representative Hewitt, nay. Representative Cleaborn?
No.
Representative Cleaborn, nay. Representative Long?
No.
Representative Long, nay. Representative Lucero? Representative Mueller?
Mueller votes yes.
Representative Mueller, aye. Representative Novotny?
Novotny, aye.
Representative Novotny, aye. Representative O'Neill?
O'Neill, aye.
Representative O'Neill, aye. Representative Pinto?
No.
Representative Pinto, nay. Representative Poston?
Aye.
Representative Poston, aye. Representative Raleigh?
Raleigh, aye.
Representative Raleigh, aye. Representative Vang?
No.
Representative Vang, nay. Representative Zhang?
No.
Representative Zhang, nay. Representative Lucero? That concludes roll call with 6 ayes and 11 nays.
Very well, with 6 ayes and 11 nays, the motion does not prevail. And members, I do appreciate the discussion and debate, and Representative Frazier, I certainly suspect you'll have this further vetting of this issue in the next committee, assuming the bill moves on to judiciary. Representative Frazier, you get the last, oh, wait a minute. Is there any other comments on the bill? Representative Raleigh.
Thank you, Chair. Now is when I want to ask the question. So specifically to Director Missel, he stated, I've got a couple questions along this line. He stated that we're not able to collect other data. Would the director please give us an idea of the other data that you had, that you were thinking of when talking about other data that's not being able to be collected? Because it sounded like you were referring to things that you'd like to see. I'd like to know what other types of data you were thinking of.
Director Missel.
Thank you, Mr. Chair, and thank you for the question, Representative Raleigh. Basically the information that would allow us to get this job done, and it goes actually to a lot of the discussion that was already has already been had in terms of it. And again, I'm not going to weigh in on the complainant, the name of the complainant piece, but for example, you know, the date, the time the complaint came in, the very general information that currently is classified, well, and would continue to be classified as private. So the way the statute's written, we'd only collect public, and Data Practices Office will tell us that the only thing that's public when a complaint comes in is the existence of that complaint and its current disposition. That's it. And actually for us, the AG's office has advised us, and there's a little bit of a conflict between the two there, that even the existence of a complaint is not public. So that without the change, then those agencies would be able to withhold all of that information, even the basics of the date it occurred and what was the nature of the complaint and that sort of thing. And obviously that's critical to us being able to carry out the purpose of the legislation.
Representative Raleigh.
Thank you, Mr. Chair. And one of the classifications that was talked about in the testimony today was the way and the method that the complaints are coming in. And so I've got two questions on how the complaints are coming in. The first one is we're seeing, we live in a world now that is based off of instant information gratification. I have the ability to tweet or post or fill out forms. In fact, I have the ability to write scripts that can go against complaint forms, and I could flood you with what's called a distributed denial of service attack. How are we going to protect against a campaign of complaints against an officer with the technology that we have nowadays and our desire for more transparency and more openness about the types and nature of the complaints that are coming in? How are we, the first part of the question is, how are we going to protect against the nature of automated complaint bots coming in?
And Director Missel, I think this gets at the issue of how the Pulse would receive that information in the first place, because you're not, I believe, the original, point of which that comes in. But Director Missel.
So with regard to the database itself, I think it's important to remember that this is not a public-facing database. There is no public access to that database. This comes from the law enforcement agencies themselves. So that's the only way it's coming in, and that's required for any number of reasons. Obviously, the security is first and foremost to make sure everything's encrypted and protected. And talking with the IT folks, this is absolutely not the kind of database that can have a public face. To your question, I would say that further down the road, if we were to, as the Post Board as an example, just like a law enforcement agency, allow online complaints from citizenry to come in, I'm probably out of my depth in commenting on how we would weed through a sustained campaign where you get thousands and thousands. I know that our board members receive thousands and thousands, literally, of emails post George Floyd incident, and I don't know that I'm in a place to say how to best manage it. I think we just kind of muddled through it. But in terms of the database and this particular, what the subject of the bill, this complaint database, this complaint information that's coming in, that's exclusively through the law enforcement agencies and is not a public-facing website or interface.
Representative Raleigh.
Thank you, Mr. Chair. And the second part of that question is, once data is in this database, and in the very limited amount of data that's going to be in there as you've discussed and testified so far, is the outcome of any investigations attached to the complaint? And how is the, and let's pick two outcomes. One is investigated and found that the police officer had done whatever was complained against. And in another one, it was found to be, let's say, exonerated. It might be one of the terms that are used. How are those two complaints, and let's say they're the exact same complaints, and one of them is exonerated, the other one is justified or found, I don't want to use the word guilty because I don't know if that's the right word, but
Sustained.
Sustained. Do you understand the direction of the question?
Yes, sir.
Thank you.
So yes, so all of this data, and that's really the point, at least as I see it, this is my take on it. The point of this database and the point of the software is that it will capture all of that information, whether the complaint's sustained, exonerated, not sustained, there's any number, and that's what we have to build into the system. So to your point, and this came up during my presentation to the chiefs the other day, this will be in my mind, if it works the way it's intended to, will actually should give us some really good data, and will allow us to report out the percentage of complaints that come in, and of that, that are sustained or that are exonerated or found, not to be to have any validity or to be completely valid. Not only that, because there'll be dispositions and other information that comes in there. If it's handled at the agency level, let's say in the case of a sustained complaint, and the agency meets out XYZ discipline, whatever that is, we would have a record of that. And honestly, if it doesn't fall within post-board jurisdiction or doesn't rise to the level of a violation of our standards of conduct more broadly, that's the end of it. But there's at least a record that there was action taken. And the same for complaints that are not sustained or are found to be exonerated. Just to add a little bit depth to it, one of the questions from the chiefs was, so if you have an officer, and this may go to Representative Johnson's commentary, more broadly about a complaint that complains about everything. If you have an officer that's in the database and they have multiple complaints against them, however, those complaints have been looked into, they're listed all as not sustained. It's really for the chief or for the post board at that point to look into it. And if it turns out that, hey, this is an officer that's extremely active, they work the night shift, and by nature of that, they get complaints, but everything has been looked into and we're good, then that's the end of it. But the point is that we can at least capture that data, know it's there, it's reviewed, and then properly dealt with.
All right, members, let's move toward a vote. Representative Rowley, I still have two other bills before me.
Yes, Mr. Chair. In the interest of time, I will pull back my last question. Thank you, Mr. Chair.
Very good questions, Representative Rowley. All right, members, then Representative Poston, I see your hand is up.
Thank you, Mr. Chair. I appreciate it. Representative Frazier, I had to jump on this call a little bit late, so I apologize if you've already answered this question. I was in another committee. Can you just tell us where this is in the Senate? Is this moving forward in the Senate? I didn't see a companion.
Representative Frazier, quickly.
It is in transit to the Senate to an author to be moving in the Senate, Mr. Bolson.
Okay.
So thank you for jumping back on. I did see you voted against that amendment, so I assumed you were on. Thanks for coming back.
Thank you, Representative. Appreciate it.
Thank you. Representative Frazier renews his motion that House File 1374 as amended be referred to the Judiciary Committee. The clerk will take the roll.
Mariani.
Aye.
Chair Mariani, aye. Vice Chair Frazier.
Aye.
Vice Chair Frazier, aye. Representative Johnson.
No.
Representative Johnson, nay. Representative Edelson.
Aye.
Representative Edelson, aye. Representative Feist.
Aye.
Representative Feist, aye. Representative Grossell, excused. Representative Hollins.
Aye.
Representative Hollins, aye. Representative Hewitt.
Aye.
Representative Hewitt, aye. Representative Cleaborn.
Aye.
Representative Cleaborn, aye. Representative Long.
Aye.
Representative Long, aye. Representative Lucero.
No.
Representative Lucero, nay. Representative Mueller.
Mueller votes no.
Representative Mueller, nay. Representative Novotny.
Novotny, nay.
Representative Novotny, nay. Representative O'Neill.
O'Neill, no.
Representative O'Neill, nay. Representative Pinto.
Aye.
Representative Pinto, aye. Representative Poston.
No.
Representative Poston, nay. Representative Raleigh.
Raleigh, nay.
Representative Raleigh, nay. Representative Vang.
Aye.
Representative Vang, aye. Representative Zhang.
Aye.
Representative Zhang, aye. That concludes roll call with 11 ayes and 7 nays.
Very well, with 11 ayes and 7 nays, the motion prevails and House File 1374 as amended is referred to the Committee on Judiciary. Thank you, Representative Frazier, Director Missel, and Dr. Erickson.